Well, good morning, ladies and gentlemen. It's my pleasure to welcome you to the Town of North Hempstead's Building Department Conference. My name is Kevin Cronin, and I am the Commissioner of the Department of Building, Safety Inspection, and Enforcement for the Town of North Hempstead. So it's now my privilege to introduce our town supervisor, the Honorable John Kaiman, for his opening remarks.
And of course, the question is, what are we doing here today? This is not something that happens every day in Long Island or anywhere in suburban America. This is not something that people do all the time, to come together and discuss building departments. Certainly we don't get 200-300 people signing up to come and listen to folks talking about building departments and government and how it should work, how it has worked in the past, and how it has not worked in the past. One of the things that we've learned over the years in the town of North Hempstead is that certainly one of the most critical functions we provide comes from our building department. One of the most important things that we do in municipal government is make sure that our communities work, that our codes are enforced, that our codes are actually effective and applicable to people's daily lives. We need to make sure that we both respect the private sector, we respect those that are doing or making a living, whether they're an architect or a contractor, whether they're somebody who's a design professional, and balancing it off with those that live in the community, that own businesses and houses, who bought a house 50 years ago and find a knock on the door with a building inspector when they try to do something today, only to find that there's something that we think is not correct. Maybe there's a deck that doesn't have a permit. Maybe there's a paneled basement that has some other features in it that don't quite match our code. And how many of those exist? 100, 1,000, 10,000? And we know, talking to each other over the years, you look at every basement in suburban America and you see something that probably shouldn't be there, simply because that's the culture within which we've existed. And so over the years, we all are aware that we in the town of North Hempstead came up against something that was a great challenge. We put in new technology in 2006 where we were going to be able to document everything that we were doing. We were going to be able to look at all of our work product. And lo and behold, look what we found. We found that we weren't so good at what we were doing. We found that we were doing things within our department that we should not have been doing. We were allowing things that should not have been allowed. We were authorizing things that should not have been authorized. And of course, it got worse from there for a while. And so our approach in North Hempstead at that time, 5 years ago, was to say we are going to reconfigure how we work a buildings department and make sure that it's done correctly. Today, tomorrow, every day. And we did it without looking at the consequences. And there were consequences. We shut down the building department for years, to the extent that every application had to have a new level of scrutiny. We found things that we never saw before. We applied rules that were never applied before. We had interpretations that had never existed before. And so we put the whole community in a world of chaos, because we overnight transitioned into a new way of looking at things. I don't know that it was the best way to do it. I don't know that it was ultimately fair to everybody. I do believe that the only way we could have accomplished what we have ultimately accomplished on the scale that we did was by doing it the way that we did. We now have a building department that is issuing thousands of permits a year. I would say that in 2005, we issued 3,700 building department permits. We went down to about 1,000 a couple years after that, just to give an indication of how much we shut down our system. However, in 2011, we issued 3,700 permits again, permits and certificates. And so we're back to the level where we once were. We are now issuing them at record numbers. We are bringing in more personnel. We are bringing in people with higher qualifications. We have better training. We have new managers. We have a new approach. We have new protocols. We have a new public discussion where people understand what we're doing and why we're doing it. And this is part of that discussion. Over the last 6 to 8 months, we've been working with the architectural organizations and the contracting organizations and the real estate organizations and community groups and saying, listen, this is what we are doing. We need to apply the codes because the codes matter. If we don't like the rules, let's get rid of the rules. But if we're going to keep the rules, then we have to enforce them. But how do we do that without crushing our community and the private sector that's trying to make a living and trying to sustain themselves in this time, in this economy? in our community. And so this discussion has led to this day, where we now have confidence that over the last 5 years, we've reorganized at such a point where we have set up a system that actually works. I used to say that 90% of the applications that we got were incorrect because something was missing, something was wrong. There was an understanding that if you put a certain number in there, you had a lot of flexibility with it in terms of square footage or size or height or depth or width. And that no longer is the case. Our interpretations were strict, and maybe we needed to come off some of those, and in fact we have. But we've gotten to a point where we now have a better understanding of how to make this work. And so what we're doing here today is, one, sharing where we are with everybody. The panel that we're now going to move into right now is about the code changes, because we understand that we need to make changes to our code, because if we're enforcing an archaic code that doesn't make sense, that contradicts another code, then we're not doing anybody any favors. And so if you apply one set of rules that contradicts another set of rules, and we hold people accountable for both, we're really not doing a very good job. And that was one of the things that led to a lot of frustration with people. But the delays now are diminishing. The frustration is leveling off. And we are almost at a point where we can give people confidence that when you apply for a building permit in the town of North Hempstead, you were going to get the same treatment every time. You were going to get a thorough analysis of your application. You were going to be treated like everybody else, and so you can have confidence that your property or the property you're working on is getting a full examination and will be thoroughly vetted, just like every other property. And when we look at the codes, we can see that they apply fairly. One of the things, I'm going to close on this, and then we're going to go into the discussion about what the code changes that we're making are, is about reconciliation. People have asked us, can we do an amnesty? Can we do something where we'll give people a break so that we're not charging 4 times the fee whenever we find something wrong in a property? If somebody has a property 30, 40, 50 years old, 5 years, 10 years, 15 years old, and they come to the building department and they want to put in a new bathroom or new this or a new that, and we find other problems. We find you did something without a vent, or you have a deck, or you have a shed that's on the setback, and we won't give you this because you have that. And now the question is, well, people aren't going to apply. They're going to do things improperly because there's too much of a headache. So then we charge people 4 times the fee. New York City, by the way, charges 10 times the fee, and I think it's 13 times the fee on commercial properties. Other people charge less, some people charge more. But maybe, just maybe, we can give people that break for a certain period of time. So one thing that's under discussion is giving an 18-month reconciliation period, starting halfway through this year and ending January of 2014, where we will let people only pay the regular fee if they fix their property. One of the problems with that is we have delays. So if we invite the whole world to come in and fix their property, then we're going to create greater delays. So we're addressing that, one, by bringing in new people. We're going to go from 1 trans examiner to 4, and then we have others that are on the payroll that are doing other types of work that's going to make it go even quicker. We're bringing in new clerical people. We're bringing in new managers. And again, we have new systems that are going to help us monitor everything that we're doing. We've also spent the last several years getting our house in order. And our house is in order. The town of North Hempstead Building Department is working. And I know that there's going to be some people out here that have your individual complaints. I understand that there's design professionals and others, whether you're lawyers or architects, that have personal grievances, many of which could be legitimate. But in our context, according to our codes, we have an obligation to make sure that we're doing things that jive with what the rules of law are. And we look at the tragedies, and we could point out to what happened in Connecticut. We could point out what happened in Long Island years ago when people have fires or other tragic events, and say, see, this is why we have to enforce our codes. But there's more to it than that. It's not simply about looking at one tragic event. It's about looking at how we as a community operate a building department, how we both protect our residents, enforce our codes, and work with the professionals in the industry so that people in this town can get the best service, can get treated professionally and properly and consistently by their government, and know that everybody is working together to make this community work. And so now I'd like to introduce Richard Finkel, our town attorney, who's going to make a presentation. We're going to then discuss some of our other codes. We're going to open it up to questions. This conference is going to go on all day. We invite, of course, you all to stay for the day, and we have more people coming throughout the day. We have several panels where we, again, partnered with the architects and the lawyers and the other design professionals and building professionals and government officials so that we can have a discussion together to make sure that we understand together how our community can best succeed. Thank you so much, and have a very strong and wonderful and fulfilling experience today. We certainly hope that you will. It will be an educational experience for all of us. Thank you.
Good morning. Rich Finkel, Town Attorney for the Town of North Hempstead. I've held the position since 2004, so I'm quite familiar with the ins and outs of what the department and what the town and what its constituents have gone through since that time. Ed Sullivan is going to speak to you about some proposed code changes. I just thought I'd talk about some of the technical and procedural aspects about how those things transpire. Just so everybody understands, they are proposed code changes. They need to be approved by the town board Thank you. They need to approve by the town board prior to their adoption, and then they need to be filed with the Secretary of State. So while these are ideas, and while the town is certainly open to additional ideas with respect to improvement of the code, just be aware that the discussion today is educational and informational, and it is not. None of these have been adopted at this point. As the architectural professionals know, as the legal professionals know, it is difficult, if not impossible, to draft a code provision that is not subject to multiple interpretations. That's why we have courts. That's why we have boards of zoning and appeals. That's why we have seemingly one legal case after another, interpreting the same words differently. It's an art to try to draft legislation clearly and finitely. The building inspectors, the plans examiners, it's their function to try to interpret what is drafted, and if the constituent, the legal professional, or the architect disagrees with that interpretation, then they do have recourse. That recourse would be to the Board of Zoning and Appeals, and if they're not satisfied with that, they can ask the court to interpret the code provision. But our goal here today is to try to take some of the ambiguity out of existing code provisions, to improve the language in there, to be more concise, and in some instances to avoid what were unintended results of existing legislation. For example, Ed will be talking about some of the front yard setback provisions, which resulted in essence of setbacks differing from house to house, and that's not what was intended at all, and we're going to try to correct that. So we'll answer questions at the conclusion of the presentation, but at this moment I'd like to introduce Ed Sullivan with the proposed changes.
Good morning, everyone. My name is Ed Sullivan. I'm with Marilyn Street Consulting. The theme I want to present to you and leave with you today is that the building department is listening. I was brought on board to review matters of policy and procedure and make recommendations to the commissioner for implementation. The conferences that we had with the design professionals preceding this conference today was a godsend for me, because we had 60, 70 design professionals, all who had their thoughts and had an opportunity to express them, and I was able to become a filter for that and put things into written form and present them to the commissioner, who will then ultimately, as Rich Finkel mentioned, present them and see if the board is interested in making some of the changes. So I'll get right into some of the changes that we're proposing, and this is only an appetizer of the changes to come. These are the ones that jumped out at me when we first started looking into this that needed to be changed, and just following up from the supervisor's point, some of the things didn't even make sense, and yet in a bureaucracy sometimes that steamroller just continues to roll. Unfortunately, it rolls over residents and design professionals alike in the quest to follow the rules. So we're here to listen. When I finish, I will give you an email address that's been provided to me by the town, and I invite anybody who has an issue they'd like for me to look into, address, and possibly make a code change. But I would ask that if you do make a complaint about the code, I would also ask that you have some sort of a proposed resolution with it, because it's easy just to gripe, but we need to try to get some real-world solutions to the problems that you may present. The number one complaint on the hit parade was resident will come in and want to renovate a kitchen. And as the code calls for in 3 different places, they have to provide an updated survey. That absolutely drives the residents crazy. Why do I need a survey when I'm not changing the footprint of the house, I'm not adding anything onto the house? Why do I need a survey? Because the code says you do. So that's the first change we're looking to implement. That's a relatively simple one, and I'm hoping that the board will just adopt it, we'll get it in, and move on and end that, because it really is. These surveys are not cheap. I'm not looking to put surveyors out of work. They'll still get the work later on when you do an addition or change the footprint of the house, but for a kitchen, you don't need a survey. The second thing, as I think Rich mentioned, block front. We were doing an analysis of, the goal is to keep everybody's house on your side of the street kind of in the same line. It's a worthy thing not to have houses back forth all over the place. The problem is, when they passed the legislation for it, they included the word block front. And block front was defined in the code as covering both sides of the street. So naturally, every block may be different. Across the street, they may have greater setbacks. When a person did the calculation on this side of the street, it caused the houses to be all over the place. That's not what the intent of the code was. So that we're hoping we're going to just eliminate the word block front from the definition in average front yard setback, and that should clear up that problem. And these are the things, like the ones that block front and the next couple I do, are sending the people to the Board of Zoning Appeals in droves. And what does that do? That backs up the calendar. The board is giving it to them because it doesn't make sense, and we're only tying their calendar up. So by doing this kind of housekeeping stuff of cleaning up the code, we're actually moving these things through more quickly. It'll free up the BZA for real matters that need adjudication. And once again, that's going to help the people get through this process a little bit faster. The residents on this one, you'll have no idea what I'm talking about because I barely do, but it has to do with pre-existing non-conforming homes that are damaged by fire. I went in, I looked, I hear the complaints, I read the code. Section 7208F says as long as you don't increase the nonconformity of the house, you could actually replace it. The problem is, our interpretation in the building department is that that's done in conjunction with another section of the code, 209, that has to do with when the building is damaged by fire or other means, not willfully knocked down. So the idea is we have some proposed language to clean those up. We're moving forward with that, and it may not make everyone happy, but at least it'll be clear and not have that constant conflict between the design professionals and the town's interpretations. We'll get one interpretation that's clear, and we're going to move forward from there. And if that needs to be changed further, then so be it. But at least everyone will know the rules of the game if they're going to play. The supervisor already spoke about the period of reconciliation. And that also, when we hear from the council people, that is a very difficult pill for someone to swallow who purchased a home that way 30 years ago, and now we're going to charge them 4 times the fee to legalize the home. People want to legalize the home. The fact that we're charging them 4 times they find offensive. I think that the reconciliation period is terrific. We'll get the notice out there. Everyone will have fair notice. Come on in, legalize it if you're going to. After that, we will take another look at whether it's 4 times, 2 times, or 3 times, whatever the number. As far as when I speak to the commissioner, couldn't care less what the maintain fee is, really. We don't take a position on that. We follow what the code says. The last one that should be an easy fix is front yard setbacks on corner properties where they have 2 front yards. It's another one. It just doesn't make sense. The front of the house is here. It's a corner property. You're not encroaching or shadowing over your neighbor's home where they have, in other situations, that's why they have side yard setbacks. So if somebody builds a tall house, it's not taking your light away from you. But on corner properties, that doesn't make sense. Yet in the town code, we require certain setbacks on each side and hold the people to them. Consequently, when they don't meet the criteria, they're over to the BZA. And it's further tying up their calendar. If we could straighten those out, we're going to do a tremendous time of freeing up the BZA calendar, trying to be a little bit more user-friendly to our residents. As I said when I started, I'll give you my email address, and if anyone in the gathering today has anything that they want to recommend for change, send it to me. I will research it. I will present it to the commissioner, and if it's valid, we will make a change. The building department is listening. You can reach me at Sullivan E at North Hempstead, one word, ny.gov. Thank you. Sullivan E, Sullivan E, at North Hempstead, one word, ny.gov. Thank you.
All right, so we want to open this up for discussion. Any questions, any other concerns? I would note that over the years we have changed some of our laws, and many of you are familiar with that. A few years back, we understood that there's questions about size of the home, how much, or how do we calculate space. And to give an example, you know, and most of you understand that uninhabitable space was not going towards square footage, was not allowed to be calculated towards square footage. So we would have designs that would come forward where the uninhabitable square face would take up a portion of the house, and then we would calculate the rest of it. And then 2 years later, go and behold, for instance, in one community, all this uninhabitable square footage that was not calculated, that happened to be, say, over a garage, just seemed to disappear in the construction of the building. But then 2 years later, when we look at that uninhabitable space, we see bay doors, a chimney, maybe a balcony coming out from that particular area that was once uninhabitable space. And we've learned that you can't quite leave uninhabitable space out of the calculations. So what we've done is we included all space into the calculations. That made homes smaller, and that was a concern. And at the time, if many of you recall, the big question, the big subject, the discussion in the papers was the McMansion concept. People were building bigger and bigger and bigger. And we understood that people want bigger houses today. It used to be that people wanted bigger lawns, outside space. Over the years, people want bigger houses because everything's bigger. People have bigger cars, they have bigger TVs, they have bigger kids. Everything is bigger. And so they wanted the house. And so space that was once not usable somehow became usable. And by us making the houses smaller, we were going against the grain, but the push was really very much the other way. And so we compromised by then agreeing, as one of the, I guess at the time, the design professionals, architects, and some contractors came to us and said, we have differences of opinion as to how to calculate the square footage when it comes to inside the brick or outside the brick. So we calculated the square footage based on outside the brick, and that actually gave us the ability to make buildings a little bit bigger because the calculations were now done in such a way that allowed a little bit more space. So we lost some space from square footage, but we gained some space through the outside the brick rule, and that was a compromise. It seemed to have worked for many in the contracting world and those that were building houses and additions. That's the type of thing that made sense. We understood years ago that the difficulty of having a house that's already built and then us finding the problem. You get a permit. You come to the town, you get a permit that the town says, yes, you can build this house. We don't see anything wrong with it. And then you build the house, and then on the back end we come and look at it. So yeah, now that we look at it, it turns out we don't think you built it correctly. We don't think the plans were correct. You're 300 square feet too big. Make it smaller. Well, you built your house. And it's not so cheap anymore to make it smaller. You might have built it smaller if you knew that we were going to find this, or we were going to challenge you on it at the end of the day. That created a great deal of concern, and certainly when we were issuing permits during a period when there was not that much oversight, we put people in a bind. And so we created an opportunity for those, if you're within a certain percentage, a single-digit percentage, but if you're within a small percentage, you can pay a fee and keep your additional space. Only to a certain extent, because you can't simply build an extra floor or 1,000 square feet and think that you can just keep it if you build it. As I've said, and many of you know, the obligation is on the applicant, the lawyer, the design professional, the applicant, the homeowner, to make sure that you're putting in plans that are within the rules. If we miss it, you still have the obligation of getting it correctly. And what happens is everyone builds to the exact level of the code. So the code lets you go here, you build right up to the quarter inch to where the code allows you to build. But if you're wrong, you're not just submitting a plan to change an amendment to your plans, you're actually now outside the code. So what happens? You now have to go to the Board of Zoning Appeals, or you have to go to court, or you have to fight with us. And what are we going to do? Our position is we can't just say it's okay to go outside the law. Can't do it. Even if it's an inch. So what do? We have struggled with that because we've created a great deal of frustration. Together, when I say we, I mean you and me and us, in trying to battle this. And we've taken the position that you have to meet the code. And you can go to the Board of Zoning Appeals, and then you go to the BZA, and it takes you 6 months, 9 months, 12 months, and there's more money, more time, more aggravation, and you're trying to explain to your client, the applicant, that it's a few inches. In one case, we had a discussion just recently where it was a 6-inch eave or a 4-inch eave over the edge of a house. I asked the code inspector, how much of an impact is this on the community? He says there's a half-inch shadow that'll be created in the back of the house that no one will ever see. So what do? It's outside the code, meaning it's not legal. And yet it's de minimis. So we're going to have a panel here on the Board of Zoning Appeals where we're talking about whether or not there's some expedited process where if there's a de minimis impact, can we have someone on our Board of Zoning Appeals meet with these, make a recommendation, have the full board, according to the law, still have a vote, but not go through this 6, 9, 12-month process. Do it in a 30-day expedited process for a de minimis thing as designated by our buildings department. That's the type of discussion that we want to have a little later on, but that's about changing our rules, changing our procedures, changing our codes to be more realistic. And yet still make sure that everyone appreciates that you have to take into consideration the law. So if you're going to build to the quarter inch of the height or the square footage or the setback, you're understanding that you're taking a risk. And maybe you should give yourself 1.5 inches, 2 inches, God forbid, and see if there's a way that you can give yourself a little latitude so that you don't actually risk going outside the code.